Hi, I'm Lauren Burns with SJF Law Group in Plantation, Florida. Today we're talking about notice to creditors in Florida probate, how to serve it, why it matters, and what happens if it's skipped. People ask us all the time, how does probate work in Florida? Here's the short answer. The court appoints a personal representative. In other states, you might hear executor. Gives letters of administration. The personal representative gathers assets, protects them, and pays valid debts before any distributions. A huge part of this is the notice to creditors. It starts the clock for bills and claims. Without it, the estate stays exposed far longer than most families expect. Quick hook from real life. A viewer told us being an executor felt like a waking nightmare. Another said an impound lot tried to bill the estate for a car no one could confirm. This step, notice and claims, often decides whether probate runs smooth or turns into stress. Step 1. Do a diligent search for creditors. We look through mail, email, bank, and credit card statements, the last tax return, medical bills, mortgage or rent, HOA, car loans, utilities, and any collection letters. Sometimes we will pull a credit report. We list every potential creditor with a good mailing address. These are known or reasonably ascertainable creditors under Florida law. Step 2. Publish the notice to creditors. In Florida, the PR must publish the notice in a newspaper in the county where the estate is administered. It runs once a week for 2 consecutive weeks. The 3-month claim period starts on the date of first publication, not the second week. We file the proof of publication with the court. Step 3. Serve known creditors. Florida requires service of a copy of the notice to creditors on each known or reasonably ascertainable creditor. We use certified mail or another trackable delivery to the creditor's best address or to their attorney if there is an open file. Service needs to happen within the 3-month window that follows the first publication. Track every mailing date and keep receipts. Deadlines in plain English. Unknown creditors, the ones you do not find, get 3 months from the first publication to file a claim with the court. A creditor you served gets the later of 3 months from first publication or 30 days from service to file a claim. There is also a hard stop at 2 years from the date of death. After 2 years, most claims are barred by Florida's statute of repose, even if no notice went out. Why this matters? If you never publish, the 3-month window never starts for unknown creditors. The estate stays open to new claims for the full 2 years after death. If you fail to serve a known creditor, that creditor's 30-day clock never starts. They keep rights until the earlier of service or the 2-year bar. That risk hangs over the estate. Pay heirs before claims are handled, and a judge might surcharge the PR personally. We see this when a PR pays a friendly bill or makes an early distribution, then a higher priority claim arrives. How to handle claims when they come in. In Florida, a creditor must file a statement of claim with the probate court. A bill in the mail is not enough by itself. We confirm the claim was filed, the amount, and the basis of the debt. If a claim looks wrong or inflated, we file an objection. Timelines are tight, so fast action is important. After an objection, a creditor must file a separate lawsuit on time or the claim dies. Watch for shady claims. A viewer told us an impound yard sent a demand for a mystery vehicle. Good instincts. Ask for proof. No proof, no payment, no filed claim, no payment. Order of payment matters too. Florida law sets a strict priority list. Expenses of administering the estate come first. Funeral expenses, taxes, and last illness medical expenses have priority over general credit cards. Family allowance also sits ahead of many debts. Pay in the wrong order, and a higher priority creditor might seek a court order and a surcharge against the PR. A few practical tips. Publish promptly after appointment. Waiting helps no one and extends exposure. Serve every known creditor with a trackable method. Keep a clean spreadsheet. Name, address, date served, tracking number, and any response. Keep the estate money in an estate account only. No personal funds in or out. A viewer shared they paid bills from cash on hand while grieving. Their lawyer told them to stop. Good advice. Wait for the estate account, then reimburse properly with records. Hold distributions to heirs until the creditor period ends and claims are resolved or reserved for. Tell the family up front. Clear expectations reduce fights. Expect government creditors. The IRS, Florida's Agency for Healthcare Administration, Medicaid estate recovery when long-term care benefits were paid, and counties for property taxes all function as creditors. Mortgages and HOAs are creditors too. Liens follow the collateral until paid. What about summary administration? If the estate qualifies and 2 years have passed since death, creditor claims are barred by law, so summary often works smoothly. If death was under 2 years, you still need to deal with known creditors in summary and make provision for payment. A simple analogy: the notice to creditors is the on switch for the claim timer. Once you publish and serve, the timer runs. Without the on switch, nothing counts down, and the estate sits in limbo for up to 2 years. Start the clock, follow the steps, and keep receipts. Tie back to the big picture. How does probate work in Florida? The PR protects assets, starts the creditor clock, pays valid claims in the right order, and only then distributes what is left to the right people. Skip the notice step, and the risk lingers, stress builds, and costs rise. If you found this video helpful, please give it a thumbs up. And if you haven't already, make sure to subscribe to our channel to be notified whenever we add a new video. Thank you for watching today.